Thank you very much for sitting in such an orderly way. So good evening to everyone, and welcome to this year's Berthold Goldman's Lecture, which is the last event, or at least public event of the Academy. And on behalf, we want to thank you on behalf of the Bureau of the Academy, Diego Fernandez Arroyo, right there, the president, my co-secretary general, way at the back, Karine Duperron, and our treasurer, Marina Metusekova, here. Before introducing the speaker, I also wanted to thank, and it's only fair that I introduce the speaker, or Julien should introduce a Julian, that makes sense. I wanted to thank all the sponsors that you will see here for the rest of the evening, because it helps tremendously the Academy to give some support to the students that want to come and assist to the Academy, and a particular thanks to the Paris Place d'Arbitrage, who actually sponsored today's cocktail that you will have right behind you once you've heard Julian's lecture. So it's my pleasure to introduce Julian Lew, who has kindly accepted to present the Berthold Goldman Lecture this year, a lecture as most of you, but maybe not all the students of the Academy, know that is always centered around an arbitral award. And this year, Julian has entitled his lecture, The Effect of Corruption on the Decisions of the International Arbitration Tribunals, from the landmark Judge Lagergren's 1963 award in ICC Case No. 1110 to current issues. But about Julian first. So he's a full-time arbitrator at 20 Essex in London. Chambers UK Bar has described him as a seasoned arbitrator and academic with immense experience acting in commercial and investment disputes. But for the students at least, let's roll back the time a little bit and the years, notably for our students. So Julian obtained his LLB from the University of London and a doctorat spécial en droit international privé from the Université catholique de Louvain. His academic interest started really early on, because in the late 70s, he was chargé d'enseignement at the Université de Namur and Catholique de Louvain, also in Belgium. But his academic, what I would say, academic masterpiece was only to follow. He established in the mid-80s the first academic institution fully dedicated to the teaching of international arbitration. The Queen Mary School of International Arbitration was founded by Julian in 1985 and is now widely considered as one of the most leading places to study arbitration around the world. Nowadays, he is the head of the school and also a professor of international arbitration. He has also been involved with many arbitral institutions. Before joining Essex, he has also been the head of international arbitration of Herbert Smith. And in the meantime, of course, Julian was appointed Queen's Counsel, now King's Counsel, in 2003. Hence, as you can already tell, Julian's professional life has been dedicated to dispute resolution. He was, amongst others, member of the LCIA Court, member of the ICC Court, member of the SIAC Court of Arbitration, and it seems like very simple things to get, but it's quite an achievement. I think already many more of us could achieve in a lifetime he has already achieved right now. I wanted to conclude with a quote which some of you, if you're like me, you've read and reread that article a few times, might or will perfectly remember. It's a bit of a long quote, so bear with me while I read it. Do you dream? When do you dream? What do you dream about? Do you dream about international arbitration? Is there a dream for international arbitration? Is the concept of delocalized arbitration or arbitration not controlled by national law a dream or a nightmare? Is autonomous arbitration a reality, or is every arbitration necessarily a national arbitration, that is to say, subject to a specific system of national law? The ideal and expectation is for international arbitration to be established and conducted according to international accepted practices, free from the controls of parochial national laws, and without the interference of review of national courts. Arbitration agreements and awards should be recognized and given effect with little or no complication or review by national courts. For those who don't know, that's a quote from one of Julian's articles entitled Achieving the Dream, Autonomous Arbitration, that was published in Arbitration International in 2006. So is it still a dream to have an arbitration as an autonomous system with the capacity to produce non-state legal norms and be practiced without references to domestic law, notably, or should I say even, when faced with corruption issues? Maybe food for thought for discussion, but now, of course, for the Berthold Goldman Lecture, Julian, the floor is yours.
Good evening, ladies and gentlemen, and thank you, Julian, for your very kind words and introduction. It's nice to hear that my paper from all those years ago is quoted, but it hasn't had as much traction and as much support as I would have hoped. And maybe I will mention him several times. Berthold Goldman might have had some sympathy with the arguments. Let me first of all start and thank all of you for coming. To listen to what is, you'll have to find out at the end whether you appreciate it. But I'd also like to thank the Academy for this invitation, and particularly those who run the Academy, and Professor Diego Fernandez Arroyo, who presides. This evening, as mentioned, I will look at the decision of Judge Lagergren back in 1963 and tell you a bit about that, and how international arbitrators and tribunals have approached issues of corruption over the years and since then. In my view, Judge Lagergren's award is one of the most significant decisions on arbitration and on corruption in arbitration. And its effect, he has influenced that decision in many ways. Now, I was honored to accept this invitation, and I'm grateful for it, but I accept it for three reasons. The first reason was indicated. I was studying my doctorate in Belgium, and my professor there suggested and helped me to persuade the ICC to come down here to do some research. The first thing happened when I got here is I was introduced to Professor Henri Battifol, one of the great lawyers, private international lawyers of his era. He was very supportive and very helpful. And he gave me some advice. He said, go to the Centre for Private International Law at the Sorbonne. They have a regular seminar every couple of weeks. That organization was run by a Greek professor by the name of Francis Kargis. I went to that on a regular basis, and there I met Professor Berthold Goldman, an amazing man. And naming a lecture in his honor is something he totally deserves. He had an energy, a spirit. His ideas were stimulating, but they were always a little bit different to the mainstream, and that's what made him so challenging and interesting. And Julian mentioned to you earlier the establishment of the School of International Arbitration. Professor Goldman came graciously to London in 1985 for the opening of the School of International Arbitration, where he presented a paper entitled Applicable Law, General Principles, and the Lex Mercatoria. The second reason I've come is to honor the memory of Emmanuel Gaillard, the principal founder of the Academy. He was a visionary. He had a drive about him. He was a scholar. He had a lot of these tremendous desire to make sure that arbitration was successful. And he was also a very successful lawyer. And the Academy carries on and being led by others. But he's remembered not only for his books, but also for other writings that he did. And Emmanuel also came to the School of International Arbitration, and he gave the annual lecture of the school in 2014 on the subject of sociology and international arbitration, which hardly anybody have heard about before that. And if you have a look at many of the conferences, including the recent ICA conference, sociology of international arbitration is now the subject being talked about a great deal. But the third reason for coming is specifically relevant to my subject today. I came to Paris because I was given access to the awards of the ICC court here and in the old building. And the Secretary General at the time was a man called Dr. Frederick Eiserman. Secretary General then, he was a kind, very practical, and a scholarly man. He was passionate to promote international arbitration, and he wanted to help develop it. He allowed me access to review and to publish sanitized summaries of awards, and it was a very controversial decision. Not everybody was very pleased about it, on the basis that they thought, well, arbitration is confidential, why is this coming out? Do the parties agree? Now, we've moved on a long way since 1972. But Dr. Eiserman stuck his neck out above the parapet as he believed, and he's proved right, that being able to review past awards is extremely helpful, not only on specific issues, but to enable lawyers to understand the way operators manage issues and operate. My focus was specifically on how arbitrators determined applicable law. At that time, there were no fixed private international law rules for international arbitration. There were national rules in most countries. There were theories and written contentions, and the Institut International had issued its resolution expressing what its members thought. And a popular general rule at that time was that arbitrators should apply the private international rules of the seat. Not everybody agreed with that. At the time, there was no guidance at all from the ICC rules itself. My research showed that different arbitrators, maybe this isn't surprising, but different arbitrators followed different approaches to choice of law. It depended on the arbitrator's background, civil law, common law, other influences. And the issues which it involved included questions of jurisdiction, the freedom of parties to select the law to govern, parties' choice of law, the application of mandatory law and loi de police, and their effect on the agreement to arbitrate, which in turn affected the jurisdiction of arbitral tribunals. I was given access to a cupboard with piles of awards. One day, I picked up an award, and that was number 1110 of 1963. It was the decision of Judge Gunnar Lagergren. That case concerned a contract for commercial representation. The claimant was a well-connected Argentine businessman. The respondent was a large multinational corporation in the electronics industry, based in the United Kingdom. The claimant's role was to promote the respondent's Argentine to the Argentine government and to help it obtain contracts for large electricity infrastructure products in the early 1950s. In return, the claimant was to receive a nice fee of 10% of the value of the contract. Well, the agent didn't succeed in the early 1950s. Some years later, this company received a large contract in Argentina, and the agent came along seeking his 10%. The issue for the tribunal and Judge Lagergren was whether the commission was due on the respondent receiving the 1958 contract. The respondent said they weren't entitled to that because the work was done for an earlier contract. Neither party raised the nature and purpose of the commission or that it was to have been used for bribery or any other purpose. They only argued about whether or not it was due on the facts. In the course of the proceedings, as the arguments were presented and their legal positions also set out, it became clear that a very small percentage of that money was for the benefit of the claimant. The remainder of that commission was to be paid to senior government officials in the hope that that would help to obtain the contract sought. Judge Lagergren raised the question of bribery, and then both parties having confirmed to him the binding effect of their contractual undertakings and his entitlement, his competence to consider and decide the case in respect of their respective claims. That wasn't satisfactory for him. Due to the bribery issue, Judge Lagergren described the contract as, and I quote, condemned by public decency and morality, which he could not, and I quote again, in the interests of due administration of justice, avoid examining the question of jurisdiction on his own motion. He further stated, and I quote again, such corruption is an international evil. It is contrary to good morals and to an international public policy common to the community of nations. Just a little intervention. That was in 1963. We'll come back to that. It's interesting to note that several legal systems were involved in this case. The parties were from Argentina and the UK. Judge Lagergren was Swedish. The seat of arbitration was in France, and the ICC has its headquarters, had it then and still now, in France. Judge Lagergren did not rely on any of these laws. Rather, he took an approach engaging international standards as he understood them, and he concluded, and this is a long quote, but it's key to the development of the law. He said the following, after weighing all the evidence, I am convinced that a case such as this, involving such gross violations of good morals and international public policy, can have no countenance in any court, either in the Argentine or in France, or for that matter, in any other civilized country, nor in any arbitral tribunal. Thus, jurisdiction must be declined in this case. It follows from the foregoing that in concluding that I have no jurisdiction, guidance has been sought from general principles denying arbitrators to entertain disputes of this nature rather than from any national rules on arbitrability. Parties who ally themselves to in an enterprise of the present nature must realize that they have forfeited any right to ask for assistance of the machinery of justice, national courts, or arbitral tribunals in settling their disputes. So without looking at any specific law on these general principles, he has decided that the case, he has no jurisdiction. I published the details of this award in sanitized form, anonymized, first in a conference in Louvain, my university town, in 1973, and then in my doctoral dissertation, and subsequently in a book in 1977. And I commended Judge Lagergren for his application of international standards to justify the refusal of jurisdiction, overriding the parties' agreement for the differences to be decided by arbitration. And I leave you with a question. Could arbitration be used in this type of a case to hide illegality of all kinds, including bribery, by going to arbitrators if they don't take this kind of approach? Well, Judge Lagergren's award raised great interest. There were, of course, those who were concerned because after it had come from the ICC papers. But there was a desire to see the award so others could reach their own conclusions rather than to follow the conclusion that I had expressed. Eventually, the ICC agreed, and the award was published in Arbitration International in 1994. That is over 20 years after I found it and published it in anonymized form, and also in 30 years after Judge Lagergren's award. The fundamental concern that commentators had about the Judge Lagergren award was that he had refused jurisdiction, and therefore he did not determine the real issue between the parties, whether the commission was due or not. And the real purpose was behind it. Well, he must have worked out what the purpose behind it was, because he did reach a conclusion that there was bribery and the contract was therefore beyond the pale. Some thought, under the doctrine of separability, which at that time was not as prevalent around the world as it is now, that Judge Lagergren should have accepted jurisdiction and determined the issues on merits and decided the commissions were not due because the object of the contract was illegal, void, null and void, contrary to international public policy. The view was that by reviewing the underlying contract, its terms, the effect of corruption on the specific circumstances, may have shown excuse me, that bribery was not relevant or material to this dispute itself. Maybe that was the case if this commission had been earned on a subsequent contract several years later. This would be relevant because practically, in some countries, corruption is necessary and accepted, expected, and unobjectionable, and without it, business cannot be done. A tribunal determining the nature and effect of the corruption in substance would also show to what extent the bribery or corruption affects international public policy at the merits stage, and then decide whether the contract is valid and enforceable. Now, before looking a little bit further into the arbitral practice, let me just digress a little bit. And let's talk about corruption. What is corruption? Well, I've just at random picked up two definitions. And let me give them to you, and I quote in both cases. Corruption is a term without a universally accepted definition, but it broadly refers to a wide variety of dishonest practices, including bribery, money laundering, embezzlement, misappropriation, other diversion of property, and false accounting and auditing. Another definition, corruption exists in many different shapes and sizes. It can be a purely domestic issue or involve foreign actors, and involves what is known as the supply and the demand, and some forms are clearly illegal, whereas others fall into more of a grey area in international investment and commercial arbitration. The form of corruption that will frequently be at stake is foreign public bribery, the bribery of public officials. I'm not going to analyze these, but where do they come from? Because there have been a whole lot of international treaties in the past 30 years on bribery. Let me give you an example. International treaties. In 1996, the Inter-American Convention Against Corruption, coming into force in 2005, the Convention on the Fight Against Corruption involving officials of the European communities, OECD Convention on combating bribery in foreign public officials in international business, February 1999. Criminal Law Convention on Corruption, entered into force July 2002. Civil Law Convention on Corruption by the Council of Europe, entered into force 1 November 2003. These are a long time ago, aren't they? The African Union Convention on Preventing and Combating Corruption, entered into force August 2006. The UN Convention Against Corruption entered into force December 2005. These are 30 to 40 years after Judge Lagergren's decision. So, was corruption just acceptable in 1963? Have these international conventions created something new? Well, Judge Lagergren said the laws of all countries. He didn't quote Jenny. He referred to France and Argentina, but there are national laws, and most national laws have some provision. In the UK, we have the Bribery Act, 2010. The US, the Foreign Corrupt Practices Act, 1997. There are rules in other countries, I believe in France and in Switzerland. There are provisions in the code which have been amended from time to time. But everybody knows and everybody accepts that corruption is something that is not acceptable. So, although these instruments and laws are comparatively recent, it is, I think, universally accepted that bribery, corruption are criminal offences prohibited by national and international law. From that, I think that Judge Lagergren was right. I'm not quite sure that he would get away with the statement of civilized nations again now. The world has changed dramatically since then. But the question is, have they become a principle of transnational commercial law and international public policy, lex mercatoria, as Professor Goldman might have argued? Or even if he didn't, has something made them an international character? Because arbitrators, when they look to determine whether a specific specific acts amount to corruption, to bribery, they would look at some law to support them, the law of the country that's involved, the international conventions that might be relevant. But are there these higher standards, maybe less identifiable as transnational law, or even a lex mercatoria? Well, this is not the place, and time does not allow a discussion in depth on how tribunals determine the existence of bribery. But I will make just a few general comments, because it comes back to what Judge Lagergren did. Where parties acknowledge that there's been a bribe, as they did in the Lagergren case, the tribunal, the parties may still agree, for some reason, that the bribery does not affect the validity of the underlying contract or affect their respective rights under the contract. A question that then follows is, how do arbitrators determine what amounts to corruption or bribery, and what is the standard to be met? How much evidence is necessary for arbitrators to conclude confidently that there was or was not corruption? Corruption allegations, and therefore findings, are not only very sensitive in nature, but also lead to serious consequences. A positive finding of corruption typically results in a dismissal of claims and or the tribunal rejecting jurisdiction, as Judge Lagergren did, or the party that is making a claim losing its case on the merits. And of course, corruption and bribery in many places may also have criminal consequences if it comes out into the public domain. Where there is no clear and convincing evidence of corruption, the trend nowadays is towards corruption being determined by a tribunal applying what the English would call a balance of probabilities, a method of, does it seem to be the case if you add up all the evidence? generally referred to as red flags, whatever they might be. They should be serious, precise, and consistent. These would include the level of payment of the fees. When you look at the overall deal, were the fees excessive, whatever excessive is, because every commercial transaction has its own way. How is that fee to be calculated? Is it work-related? The amount of time spent, the efforts involved? How long have the parties been in business together? How long has this relationship been going on between the parties? Or is it just a one-off? If you get me this, I will pay you that. Are there mutual obligations to both sides? Is there a reporting duty? Is this a proper relationship? And also, as was the case in one particular case, the practices and commercial environment of the state concerned, where, despite what Judge Lagergren said, bribery may be something which is accepted, or at least a closed eye is used. There is no settled practice on this question. It depends on the particularities of the case, the applicable law, and the members of the tribunal. And there's a certain amount that is shown both in writing and also in cases of how the red flags are dealt with. A further important element which remains to be determined in each case is the way tribunals approach the issue of corruption. Broadly speaking, there are two views. And a line of cases dealing with corruption without going into too much detail show that arbitrators sometimes will follow and confirm in the way that Judge Lagergren did the question of jurisdiction, although it now seems more likely that they will look to actually deal with the jurisdiction question as a preliminary matter rather than accept jurisdiction in part. And this is shown in an example in 1984, that's going 20 years post-Lagergren, in which the tribunal did not follow his approach. Again, the facts were very similar. An agent sought to recover monies it had paid to government officials to obtain certain contracts for the respondent. The respondent argued that the agreement was void because the agent had sought to influence government officials through secret payments. And in any event, the agent's efforts had not been effective. So there we're getting into substance. The job wasn't done properly. The arbitrator accepted jurisdiction. The corruption was, and also said, corruption was widely accepted as a means of obtaining contracts in that country. He then concluded that the base agreement, the agreement to make these payments, was void, and the claimant was not able to recover the secret payments ostensibly made on its behalf. There are other cases. I'm not going to mention them because they are all examples of very similar things on the commercial side. But there's a similar approach has been taken in several investment arbitration cases where the main claim was usually the investment in question, often a contract or an investment contract allegedly procured through a corrupted activity. And there have been quite a few cases where corruption has been raised in investment cases. Of course, the best known case is an ICC case in the world duty-free, where bribery complaints were upheld. The respondent state alleged that the investor had obtained the contract by paying a bribe to the former state president. And the tribunal found that the claims based on contracts of corruption or contracts obtained by corruption cannot be upheld. The evidence in this case was sufficient for the tribunal to conclude that bribery did occur, and for that reason the claimant's claims were dismissed. But here's the issue. There are numerous cases of investment cases where corruption has been alleged on various bases, which arbitrators have taken into account, considered very carefully, listened to the arguments, sought evidence, sought additional evidence, and then came to a conclusion, in some cases, that there was corruption, but more of those cases where the arbitrators have decided that there wasn't corruption. There might have been, but it was not directly relevant to the case itself. So it's a rather interesting situation that these decisions are being made, leaving the effect of the corruption in the air, or just be allowing it to be watered over. And of course, because these are international arbitration awards, they may be published. We don't always know what they are, and there is an uncertainty. But the general principle remains, I think, that investment arbitration and commercial arbitration does recognize that corruption shouldn't occur. And why? What are the effects of corruption? Well, in one of the reports that I said that I looked at last week, there was an explanation that the problem with corruption is what its effect is in the jurisdiction where it's happening. And it gave 4 reasons. Political, economic, social, and environmental. Politically, it can be a major obstacle to democracy and the rule of law. Economically, it depletes national wealth and is unfair to others involved. Socially, corruption corrodes the social fabric of society, as well as undermining the political system. And environmental degradation may also be a consequence of corrupt systems. Now, of course, we can only judge these on the basis of actual facts, actual cases which come to everybody's mind. It's very difficult to make any decision on generalities. But if you think of the things that we all read in the newspapers on a regular basis, where one of the newspapers or television programs are doing a study on something, so many of these cases come up. It's not for us to judge. We are no more than the public when we're reading things of that sort. But there is an issue that arises. Coming back to the issue of Judge Lagergren, these cases also seem to show that Judge Lagergren's approach of saying, "Oh, bribery, I'm out of it, I don't have jurisdiction, this is disgraceful," and then, of course, tearing the parties apart, even though he's admitted he didn't have jurisdiction, that is not what seems to be the way things are going now. It's interesting that the proposition is that nowadays, based on widely accepted doctrine of separability, the modern approach is that both nationally and internationally, so tribunals to conclude that allegations of corruption do not automatically deprive the tribunal of jurisdiction, but rather allow arbitrators to take jurisdiction and give them an obligation to take jurisdiction to determine whether the actions were corrupt, or the alleged actions were corrupt, and if so, to decide what is the effect of that. And they can do so as part of the merits, and they do on occasions, and they can also do so on a preliminary basis, as frequently occurs. In conclusion, let me say this. I think it is widely accepted in principle that corruption, both in a domestic national context and in international commercial affairs, is corrosive. For this reason, corruption's effect on international arbitration is important. I think it's increasingly important. and in many cases, arbitral tribunals are on the front line in upholding and protecting and maintaining accepted international standards. Well, arbitral tribunals may be, but are those who act as arbitrators the right people to be an international judge and to uphold the standards they did with a kind of strength that we saw from Judge Lagergren? Let me leave you to take away 3 questions. Now, normally I would do that with students, leave the class and hope they'd answer it next week. I won't be here next week, but I'll still leave these questions with you. First, when arbitrators have determined that the underlying transaction has been affected by bribery or corruption, should they reject the case on jurisdictional basis and deny the parties a decision on the merits, which is what Judge Lagergren did? Or should the tribunal determine the parties' claims and defences on the merits with the taking of time and the costs incurred, and they decide whether the underlying contract has been affected by corruption, and if so, dismiss the case on the merits rather than purely on jurisdiction? My second question: are the issues of bribery and corruption and any other similarly abhorrent practices, people smuggling, illicit drugs smuggling, illegal armament trades, terrorist activities, and there are other examples we can come to, are these contrary to international public policy, such that they are illegal and unenforceable per se, in themselves, automatically, as Judge Lagergren suggested, and without any reference to national law? Do you think that Professor Goldman would have considered these activities illegal, immoral, unenforceable, and contrary to international public policy, part of the Lex Mercatoria? And third, should arbitrators ex officio raise the existence of bribery where they suspect its existence but absent specific evidence? Should they seek evidence from the parties, or generally, to prove or refute their concerns of bribery or corruption or other illegality within the context of the underlying contract? In this context, are arbitrators the guardians of international commercial mores with a duty to uphold fundamental and accepted standards of international trade, even if the underlying contract is valid in other ways, perhaps under the applicable law, or even accords with normal, accepted international commercial practices? Should arbitrators strike down violations of those standards, even if not raised by the parties? I'll leave you to think about that. Thank you very much.
Thank you very much, Julian. We can take a few questions for about 15 minutes, so if you have any questions, please raise your hands. Go ahead. Yes.
Thank you very much, Professor. Just in relation to the question you posed us, if I may have a slight variation on that. Should judges, and this is a British context, in terms of the Section 68 challenge under the Arbitration Act 1996, should judges take great care where those proceedings are engaged in making findings and in possibly instructing lawyers to their representative bodies, and in effect causing reputational damage which could be irreparable, notwithstanding what the respective regulatory bodies find, and much wider, causing irreparable damage to arbitration dare I say, from a judge or judges who may not be very familiar with the system, and especially where a judge has issued quite a lengthy judgment and has then refused right to appeal their own decision? That's my question. Thanks.
It should work, I think.
Thank you for that interesting question. It's a little bit English-oriented, but let me just touch on a couple of points. First of all judges, everywhere. There are some bad judges, but not many. In most countries, the one thing about our judges, they want to get it right. But they are appointed, unlike arbitrators, they are appointed by the state in accordance, in every country, whatever the system is for appointing judges. And we do hear criticisms of the judges. But they want to get it right. And I don't think that, and I think that in most cases, judges do take great care in reaching the conclusions they want. And that'll be the case also when there have been cases coming before a judge in England as to whether a decision should be set aside or sent back to the arbitrators. Of course, all issues are serious. They're very serious and very important to the parties. That's why they've ended up in an arbitration. And my view is that if they've selected arbitration, with some exceptions, and Julian referred to this in his entries, I believe that what an arbitration clause says is, excuse me, Mr. Judge, stay out of my business. I have chosen to go to another jurisdiction, to arbitration. Now, we would recognize if there's a contract that says parties from one country to another, we choose the jurisdiction of the English courts, we'd recognize that. There's a choice of the English courts, and we'd expect the foreign courts to recognize that's what the post is. Same about arbitration. Parties have decided to go to arbitration under whichever system, wherever the seat, that's the party's right. With again, the one or two exceptions. And that's where corruption comes in, because corruption is a difficulty. And that's why I asked that last question. Is it the arbitrator's judge to police it? Who otherwise polices corruption?
Other questions? Yes, go ahead. Yeah, you have a microphone coming.
Thank you for your wonderful lecture. And my question to you is that when we see a well-reasoned award, sometimes we see that there are some things which are not that reasoned particularly. So how to trace a corruption, if there is any, in a well-reasoned award? Are there any parameters or any few points which I should take care while reading an award? Thank you.
Well, reasoned awards are something which has become a mainstay for international arbitration. Some complain that the awards have got too long because every argument that's put, some national court or some supervisory body is going to say, have you answered every question that was floated, whatever its merit? I don't want to go there, but I know, I can only say this from my own experience, which is inevitably limited because of the cases that I've been involved in. Arbitrators try very hard to explain why they've reached their requirement. And in fact, if I remember correctly, it was French law which initially said you couldn't enforce an award without reasons. The arbitrator had to justify himself. Whereas in England, it wasn't necessary. In America, it wasn't necessary. Arbitrators could say, this party's right, that party's right, or wrong, and this is the consequence. Now, internationally, we've now got a much wider acceptance that there should be reasons, and those reasons should be explained. Whether today we are making arbitrators go too wide, that's for a discussion on another occasion.
Any other question? Yes.
Again, thank you so much for the lecture. My name is Kanyeri Kariuki. I'm from Kenya. In fact, the exit case you mentioned, World Duty Free, was brought by World Duty Free against Kenya. but the ruling was based on the fact that the evidence from the corruption was due to the investigations done at a local level. And that's, I think I'd side with the judge 60 years ago, in the sense that arbitrators are not judges, because from arbitration, this is a contract between two private individuals, and corruption is a matter of national importance. And I reckon as arbitrators, we shouldn't, or rather as counsel, go that way, but rather morph the whole practice to involve a bit more national, or instead of a national court, precisely national procedures in matters of corruption, moving forward with our practice. Or
look, this is a very good. This is a, I think, a very interesting question and a complicated one. But the question is this: if, where the parties have agreed, whether it be under a treaty or under an arbitration agreement, to go to arbitration when disputes arise, they have agreed on that process. It is possible, and there are exceptions, where the law of different countries restricts issues being dealt with in arbitration and requires it to go to the national courts. But the cases we looked at, and we get all the time, are international. Somebody's from there, somebody's from there. One of those parties may or may not be a government, state-owned, could be the government, could be the state, could be a state-owned entity. And in those circumstances, the dispute has arisen. And when the issue of corruption arises and what the effect is, that's one of the reasons why increasingly we've seen arbitrators accepting jurisdiction, collecting the evidence, receiving the evidence, listening to the legal arguments, making a decision on how this matter should be resolved, because they want to know exactly what is the effect of this corruption. Was there an effect? Maybe there was corruption, but it had nothing to do with the underlying contract between the parties.
We can take one last question, if there is any. Yes. Only question from the students tonight.
Thank you so much. What's your opinion about the recent tendency to extend or create civil or penal liabilities to the arbitrators that don't use the same mechanism as judges to deal with corruption in the merits? Should we consider it as a valid exception to the arbitrable matters that should be discussed in any kind of process?
I'm going to ask you to repeat that because I didn't get most of it.
Can you repeat the question slower?
Oh, sure. What is your opinion about the recent tendency to extend or create civil or penal liabilities to the arbitrators that don't use the same mechanism as judges to deal with corruption in merits? Should we consider it as a valid exception to the arbitrable matters that should be discussed in a process?
Do you think civil or criminal liabilities for arbitrators is a potential for the future if they don't address properly the issue of arbitration? If I understand the question properly.
If that's the question, whether there should be liability for arbitrators of a criminal or a civil nature, it's a very dangerous question. The first thing, we go back to basics. The parties have decided for whatever reason that they would rather go to arbitration than a court. That's their choice. They've decided to resolve that matter, their disputes, that way. Provided there's no element of dishonesty, they take a risk of dishonesty. They take a risk of arbitrators not reading the papers. They take that risk. But there'll be very few cases where those kind of allegations have been made. There's always, I would say always, invariably, an unhappy party at the end of an arbitration, where a party feels they didn't win, maybe they didn't get exactly what they wanted, the tribunal didn't understand their arguments. But I don't see the issue. Once you start putting on take away arbitral immunity other than in limited situations or imposing criminal sanctions on arbitrators, you destroy the arbitral system. And again, let's remember, if we live, as we do in some countries, in a market economy, parties make the decision. They are not going to arbitration because the government tells them to, and they're not even going to arbitration because people like myself and other professors of arbitration say what a wonderful system it is. That's not why they go to arbitration. They go to arbitration because they consider that it's more appropriate for various reasons to take their dispute to this independent, neutral system. And they choose, whether it's the ICC or the London Court of International Arbitration, or any of the other very good systems around the world. That's what they choose. And I think that if once you interfere with that, you narrow the choices.
Well, thank you very much, Julian, for this very interesting lecture. And thank you again for coming to do that for the students today. And so now, time for the cocktail. Thank you very much.